Thank you, Mr. Chairman. I interviewed Melvin, he pronounces it Thigpen, back on April 22nd of this year. He's presently housed at the Joliet Treatment Center. And he was the only person present besides myself. Mr. Thegpen has been incarcerated now for more than 48 years, since December of 1975, for an aggravated kidnapping, rape, and attempted murder that occurred. I would say that just by way of description of the circumstances of the interview, he was self-ambulating and alert, attentive, and respectful. He was very difficult to understand at times. He's not able to speak clearly to my, in my estimation. He reported that his health is good, other than some minor difficulty with some excretory functions. He had nothing with him, but he participated fully in the interview. That's of some significance because prior to that interview, the file reflects that he had essentially refused to participate in any parole-related interview since at least 2006. I attribute that change in all likelihood to the change in his housing arrangement. He had been housed for many years at Dixon Correctional Center to address some of his mental health issues. And once the Department of Corrections was able to establish residential treatment centers, including at Joliet, provide a more therapeutic environment, I think it's actually working to his benefit, his health benefit. Regarding the offense itself, or the offenses for which he was convicted, the file reflects that on December 1st of 1975, a 17-year-old girl was attending Rich East High School. She stayed after school to attend cheerleading practice, and after practice, she walked alone down a school hallway to the parking lot of the school, and it was there that she encountered then 22-year-old Mr. Thigpen. He asked her if she'd been at girls' volleyball. She tried to ignore him and continue walking to the parking lot, but he grabbed her arm, placed a gun to her back, told her that he had the gun, which she did in fact see, and then forced her out of the school at gunpoint and into his car. He drove her out to a rural area and sexually assaulted her at gunpoint. After assaulting her, he engaged her in a conversation, asking her what her age was. She actually underrepresented her age, said she was only 15 years old. And his response was, "Oh, you're just a baby, I'm so sorry." Mr. Thigpen then told her that he would take her back to the high school, but instead he drove a short distance and forced her out of the car into a ditch. While she was lying in the ditch, he pointed the pistol at her and fired it a total of 4 times. The first shot struck her in the right side below her ribs and exited out her back. When she screamed, he fired a second time. The second bullet grazed the left side of her body. She screamed again, and Mr. Thigpen fired a third time, on this shot, missing her. After the third shot, she pretended to be dead. He began to walk away, but returned one more time and fired a 4th shot at her. The 4th shot struck the ground approximately 2 feet away from her while she was lying in the ditch. Because she was pretending to be dead, and when he believed she was so, he left the scene. Once he was gone, she made her way to a nearby farmhouse to get help, was taken to a hospital, and thankfully survived. She identified Mr. Thigpen in his car to authorities. He was eventually located, found guilty at a jury trial, and sentenced to 50 to 100 years for each of the 3 offenses I mentioned earlier, all to be served concurrently. 3 years after his sentencing, he filed a late notice of appeal, which was denied because it was untimely. Therefore, there was no appellate review of the trial result or the sentencing. It's noteworthy that the file reflects that in some of his prior interviews for parole purposes years ago, he is reported to have made several, I think, delusional statements, including things like, "The judge sees me every day. The judge has all the keys." That Mr. Thigpen does not want to get out, that he owns financial institutions all over the country, and that he doesn't want to see the parole board and that his work is here, meaning in the prison. In my interview with him, it sounded to me, as best I could tell from his difficult communication patterns, that he was saying that that he had not actually been convicted and instead has experienced a mistrial and simply was not ever retried or released thereafter. I told him that the information in the file contradicted his assertion that he had actually never been convicted. He did not have a response other than to repeat his remark to me regarding the mistrial. There is some information in the file reflecting a dispute regarding facts. It didn't affect the outcome, but Mr. Thigpen's mother had actually sent a letter disputing the information that the police had provided regarding her son's conduct, regarding the victim's statements. She had made statements about the color of his car, and she said that didn't match the color of her son's car. So the point of her letter being that he was perhaps wrongfully identified and convicted. Nonetheless, as I said, there was no appeal and nothing ever came of that. There has been some other litigation regarding this case, but it all really related to his incarceration and receiving forced medications for his psychiatric condition. Other than that, not noteworthy for today's purposes. I think it's fair to say that Mr. Thigpen did not acknowledge the facts of the crime or take responsibility for his actions, at least in the interview. Didn't say anything to express any remorse for his actions, therefore, and no other specific details somehow about his involvement. I did ask about his life circumstances prior to and at the time of the offense. He really didn't provide much. He said that he had a brother who he now hopes he could live with if paroled. The brother is supposedly 2 years older than Mr. Thigpen, but there's been no contact with the brother in any visits or calls during his incarceration over these last 48 years. He has some criminal history apart from these offenses. In 1970, he had a conviction for criminal damage to property. In 1973, he was arrested for an aggravated battery and rape. The allegations in that case involved the abduction of another girl from a nearby high school in the Chicago area by knife point. According to a letter from the Cook County State's Attorney's Office dated June 2018, Mr. Thigpen also was placed in a lineup on 2 prior occasions so that the other female victim could identify him, which she only did conditionally, but failed to make positive identifications in their judgment because of fear of retribution. So there was no prosecution of that case. Mr. Thigpen had a difficult institutional adjustment, at least in the earlier part of his incarceration. There were a total of 113 tickets issued. Most of those, however, related to a failure to submit to medical testing. He did have a number of tickets for fighting or assaults, but none since May of 2013. He was born in Jackson, Mississippi, raised by his mother. His parents divorced. She worked at a Ford Motor Company outlet in Chicago Heights. His father also lived in Chicago. The records reflect that he has a son, according to a pre-sentence report that was prepared in 1976, but no other details about that, and he has had no contact and didn't express that he'd had any contact with that son. He has not had any employment within the prison system, no IDOC jobs or programming. I think it's unfortunate, but there's no indication of any parole plan other than his statement that he would intend to live with his brother. He denied to me having any or needing any assistance from any other groups or programs. He says he has everything he needs. There are no letters of support recently in the file. There was a letter in the file reflecting a petition that was circulated in his community where several hundred people appeared to have signed in support of his parole release, but no basis is clear as to why and what the reason for that support and what their intended efforts were going to be to assist him. And as I said, that was years ago. There was a letter from a childhood friend in the file offering him employment in a car mechanic business in California, but that again was a statement from many years ago and nothing to suggest that that offer is still in place. There is a letter from the state's attorney's office stating that before he would ever be paroled, the state's attorney's office would like to have a delay of the effectuation of any parole so that they could seek status of him as a sexually violent person and that he could be detained on that basis. I think any discussion of the details of his psychiatric condition probably need to be discussed in closed session. If any of the board members want to go into any detail about that, obviously the information is available to you. You may have already seen it in the file. The state's attorney's office has consistently opposed the parole for this offender. The last letter they submitted, however, was dated 2018. And again, we would need to go into closed session for me to go into any detail about objections or protests from the victim of the offense or people associated with the victim. Regarding prior en banc history, as I said, he hadn't participated in interviews prior to this since 2006, but there have been multi-year sets on several occasions, typically 2 or 3 year sets. This was last heard in 2021. He was obviously denied parole at that time and given a 3-year set. There have been a handful of votes through the years against him getting a multi-year set, but there have not been any votes that I could find in favor of him being granted parole. That's the extent of what I have to talk about in open session.
Do you wish to make a motion to go into executive session?
Maybe we should briefly.
Okay. The motion has been made and seconded to go to an executive session. Those in favor respond by voting aye.
Aye.
Any opposed? All right, we're going to ask you to leave one more time and then we'll bring you back shortly.
I would be prepared and am prepared to move to deny parole for Mr. Thigpen at the present time. My reasoning is that there is no parole plan provided for by Mr. Thigpen or that as a parent. And given his psychiatric history and condition, I think that the absence of the services necessary to address his medical needs is a serious impediment to us being able to ensure public safety should he get released at this point in time. His disciplinary record, as I mentioned, while it's been better since 2013, was problematic for many years. Out of respect for the concerns expressed by the victim of the offense and because the parole would deprecate the seriousness of the offense and promote disrespect for the law, I move to deny parole at the present time.
Second.
Motion's been made and seconded to deny parole. Is there any discussion? Seeing none. Ally, call the roll.
Mr. Heaton,
Yes.
Mr. Boland,
Yes.
Mr. Coates,
Yes.
Mr. Delgado,
Yes.
Ms. Globoker,
Yes.
Mr. Grubbs,
Yes.
Ms. Schofter,
Yes.
Ms. Taronis,
Yes.
Mr. Chupi.
Yes.
9.
Is there a second motion?
I do not actually have a second motion. I don't think a multi-year set is appropriate in spite of the fact that there have been several in the past for Mr. Thigpen. The progress that he appears to have made once he was moved to the Joliet Treatment Center gives me some hope that he could continue to improve and perhaps get the benefit of some assistance in preparing a parole plan and give us a chance to reconsider. So I do not intend to make a motion for a multi-year set.
Okay. Any other board members want to make any motions for this? Will this cause the victim to have to respond again in the next year?
Well, she'll be contacted and given that opportunity, whether, she'll want to avail herself of that. It'll be her decision, of course. I think the file is sufficient to address the concerns of any victim or victim-related person. So not necessarily.
Okay. Seeing no further motions, that concludes that case. We'll go on to the last case. We're going to take a short break for some of our staff, and then we'll call the last case.
Okay, so let's unpack this. And thanks to Richard, we actually have a unique insight into this, and that is a blog post from a jury member who sat jury for this trial. And she writes a vivid accounting of this trial that we're going to go through. And there's also a little bit more information that we can see from the board itself. They do a great job with documentation in Illinois. It seems much more comprehensive, or at least the information is more readily available and digestible from Illinois than other states. One thing to note from this hearing was, again, it's just so interesting, the contrast of Illinois between Illinois and Connecticut, and Iowa. It's like, it's just different worlds, and it's not what I expected from Illinois. Maybe not what you expected either, but also the whole process. Like, if you put this footage in black and white, I would believe that it was an Illinois parole hearing from like the 1930s or 40s or something. It's just totally different than what we see in the other states. I mean, it could be, and the process is much more official with all those board members there, and very a matter of fact, and very quickly they denied. The one objection I have to this, though, was how they are allowing him to have another parole hearing in a year. They could have said, you won't get another parole hearing for 10 more years. And one of the board members, good for that board member, said, well, what about the victim? I mean, aren't we going to have to reach out to the victim again? And the response to that was, well, yes, we would, but the victim doesn't need to participate. We can take what she already said on record. And I just didn't like that. That wasn't the response. That it wasn't, it to me, just that response seemed very unempathetic. It's like, we know what this causes to victims. It for them to know that there's going to have to be a whole nother year, that affects them for the entire year. The not knowing if, oh my God, really, I have to not know if this monster is going to get paroled in a year. Now, I would hope that people would talk to her and say, look, it's not. But even that rationale doesn't make any sense to me, because no one ever knows. No one ever knows, and if you'll get parole or not, and the trauma that it causes to the survivor here. And man, if you want to talk about a survivor shot 3 times, gets shot at the 4th, plays possum, so to speak, and then walks to a farmhouse. I mean, talk about, and then to point him out, and we're gonna read if she stood trial or not. Stood up, and so it's just incredible. Really is. I don't know why he would deserve to have a hearing in a year. You can tell he's totally like it should never be free. It's not even. So anyways, I had a problem with that, and someone on the board should have put an end to that, in my opinion. But let's go read from the testimony of the jurors. So the last time I served in a jury was in 1977. I was an alternate for 2 weeks. I drove to felony court in Harvey, Illinois, and listened to testimony in the case of State of Illinois versus Melvin, Thigpen. Mr. Thigpen was charged with abducting a high school girl from cheerleading practice, driving her out into the country where she was sexually assaulted, thrown into a ditch, and shot 3 times. The state laid out their evidence. For 2 days, we heard testimony from police, evidence technicians, and medical professionals. Some of the witnesses were clear and precise, others fumbling and inarticulate. The evidence was delivered without emotion or drama. On the 3rd day, we heard from Carly. She was the victim. There we go. And she stood up in court. Carly was poised and soft-spoken, but her voice carried, perhaps because it was so quiet in the room. She had given police artists a detailed description of her assailant. The sketch that the artist created bore a striking resemblance to Mr. Thigpen. Carly described how she had been grabbed in her high school parking lot, held at gunpoint, and driven off into the country. She described the nubby texture of the car's upholstery and the paisley pattern of her assailant's nylon shirt. She explained in extreme detail how she was sexually assaulted, then dragged from the car and thrown into a 10-foot drainage ditch. As she lay in the muddy ditch, she heard a gunshot and felt a burning sensation in her side. Then 2 more shots. One bullet hit her in the thigh and one grazed her neck. She played dead. And after several seconds, she heard the car door slam and the sound of spitting gravel as her attacker drove off. When she had finished testifying, the state's attorney asked if the assailant was in the courtroom. Carly looked at the defense table, raised her arm, and pointed to Mr. Thigpen. Her face betrayed neither anger nor hate. She was not afraid. She was serene, triumphant. She had survived, and now she had her day in court. That was 35 years ago. How beautifully written by this jurist. And again, to think, though, that she's going to have to wait another year if this monster is going to get paroled. And remember, this monster, well, we can go over it in more detail, but he had 2 prior offenses, but the victims in those offenses were too afraid to point him out in a lineup, and they couldn't convict him. And isn't this a contrast? The next day, I called Ron, the foreman, to the jury, and an insurance adjuster for Allstate, who I had lunched with on several occasions during the procedurals. He told me that it had taken them 3 hours to find Melvin guilty on all charges. There had been no dissent amongst the jurors except towards Ron, who insisted they go through all the evidence before they voted. All right, that's the proper thing to do. Plus, you can have lunch while you do it, right? Oh, I skipped a part. The next 5 days of trial were taken up with procedural arguments and much spent of the time in the jury room, not discussing the case. The defense took 1 day to present their case, and we listened to impassioned closing arguments by both sides before the judge gave us his instructions. The jury was escorted back to the jury room, and I was an alternate, was sent home. Like one of those survivor contestants who don't make the grade. For weeks, I checked out local news to see if there was a report on his sentence, but there was none. I figured I would learn what happened. I would never learn what happened to him. 10 years later, I was reading an article in the Wall Street Journal on career development in prison. In their lead, they featured an inmate in the Joliet Correctional Facility named Melvin Thigpen, who was serving 15 to 20 years for sexual assault. The journal writer reported that Mr. Thigpen had become an accomplished watercolor artist. Well, he's serving more time than 15 to 20 years. His full term, I mean, I don't understand that part. His full term is 2047. Jury duty notice. Last month I received jury duty notice for the court. I had been selected for jury duty again. In the intervening years, I had been called several times. Let me see. Okay, so that's it about this case. How well written, though. Very good job. So now the where they talk about the prisoner review board, the information that we spoke about. Let's see, with his other crimes. It's here. And again, thank you, Richard, for pulling up all this research and showing it. And it's like interesting with this case because they don't bring the actual perpetrator to come to the parole hearing. So I wasn't, that's why I delayed on showing it. But really, it is a fascinating case, especially with the information Richard brought to us. So a true survivor, right, who put him away. Presentation, interview, and file. Melvin, who was 68 years old at the time of this parole hearing, serving 50 to 150 years. So statement of facts. On December 1st, 1975, the victim, a 17-year-old girl, was attending Rich East High School. She stayed after school, attending cheerleading practice. After practice, she walked alone down a school hallway to the parking lot of the school. It was there she encountered a 22-year-old Thegpen. The Thigpen asked her if she had been at girls' volleyball. She tried to ignore him and continued walking to the parking lot. He then grabbed her and placed a gun in her back. He told her that he had a gun, and she, in fact, did see the revolver. Then he drove her out to the rural area, did his thing at gunpoint. After that, he asked her what age she was, and she said she was 15 years old, thinking that he would, thinking it would help her. He replied, "Oh, you're just a baby. I'm sorry." Mr. Thegpen then told her that he would take her back to high school. Instead, Mr. Thegpen drove a short distance and forced her out of the car into a ditch. While she was lying in the ditch, he pointed a pistol at her and fired a total of 4 times. He's a monster. The first shot struck the victim in the right side below her ribs, exited out her back. When she screamed, he fired a second time. The second bullet grazed her left side of the victim's body. She screamed again, and he fired a third time, missing her. After the third shot, she pretended to be dead. He began to walk away, but returned. He had to return to fire the fourth shot, and the fourth shot struck the ground approximately 2 feet away from her. I just can't even imagine. Then that's where she laid in the ditch. She made her way to the farmhouse to get help. And then she was taken to St. James Hospital. The victim identified both him and his car. And you can see his mother was like, well, it was the wrong car color. It's like, okay. He was found guilty by a jury and sentenced. I know that moms, you can't believe. You just don't want to believe it. But that also means that he's still denying it to her. The 3 years after he was convicted, the sentence he filed right? I mean, that's what it would mean. That he hasn't told his mother he did it. On April 29, 2021, he refused an interview, and he has since 2006, during prior interviews with the board, he had made delusional statements, including that the judge sees him every day. This is what the guy told him. Can you believe they would even give him a chance of parole because he showed a little bit of progression? It's just stupid. It really is. This guy, at the expense of no. They needed to just say no on behalf of the victim, the survivor. Now, his criminal history. He had criminal damage to property, okay. But May 1st, 1973, he was arrested for aggravated battery and sexual assault. The allegations involved the abduction of a girl from a high school at Knife Point, according to the Cook County State's Attorney. In attorney's opposition letter. He was also placed in a lineup on 2 prior occasions in which females victims conditionally identified him but failed to make positive identification because of fear of retribution. So it's my understanding that there were 2 prior to the 1973, so there were 4 known incidents of this. Okay. During his incarceration, he accumulated 113 disciplinary violations, most related to failure to submit medical testing. However, there are a number of tickets for fighting or assault, but none since 2011, when he received a 1-month isolated confinement for fighting. It indicates that he has held that he has held no job assignment during his incarceration. He currently resides at the treatment due to mental health. Okay. Yeah, go even give this guy parole, because it's great. It's great to even give him the option. That's just okay. That is one insane action that we saw by Illinois here. Just say no. I do love these reports, though. They're just so well done. Okay. And hey, let me know if you still want to see these type of hearings, even though we don't see the inmate. And I'm going to put this on memberships, and then I'll probably play it in a premiere. I'll mix it in a premiere with other hearings sometime in the future. And with that, I'll let you go.